Thank you, Mr. Speaker. It's an honor to rise here today on the traditional territory of the Algonquin Nation, Meegwetch. Mr. Speaker, I can't help telling you how much I really had hoped you would let me ask the question to the member for South Surrey, White Rock. And I'm going to tell you why now, because I think people might enjoy this. The honourable member for South Surrey, White Rock mentioned that she used to practice law. I used to practice law. And when she was a member and actually within the governing party when we were both first elected in 2011, she helped me with a family law case. So I just wanted to put that out there. One of my constituents had a grandchild pretty much kidnapped by a non-custodial father who took a toddler to New Hampshire. And I was going crazy with the mother and the family trying to figure out how to get the baby back. Speaking of judges I don't like, I would mention the family court judge in New Hampshire who thought that a Supreme Court order from the Supreme Court of British Columbia for full custody for a little girl was something out of a Cracker Jack box that they were free to ignore. It was quite the case, but the honourable member for South Surrey White Rock gave me some very good advice, and it helped me get the baby back, and she's now 16 and living with her proper family, and it all came out quite well. Anyway, there's a minute and 15 seconds gone on what I want to talk about, which is Bill C-9, and reforming the Canadian Judicial Council. Speaking of, as I was, U.S. judges, it reminds me of this whole experience of thinking about judges. When I was at Dalhousie Law School, we had one professor who challenged us, one case, one day, where we spent hours trying to figure out the rationale for the judge's decision. It made no sense to us, but obviously the judge had ruled us, so we had to figure out the legal reasoning, because there must be legal reasoning. And it was a contract case, and it made no sense. And after about an hour of us tearing our hair out and putting forward solutions, our professor said, "Is it permissible to ask if the judge was bribed?" He was. That's why this decision makes no sense. And he was thrown off the bench for it. So it was an episode for us in real life judicial reasoning. Sometimes the judge is bribed. Now, that doesn't happen in Canada that I can, and in terms of, well, it might happen sometime. This is why we need a judicial review process. This particular process has been in place since 1971, and there are good and real reasons it needs to be fixed. Also, a real-life case that I found at least explanatory, and it will, for the general public who may have been watching this debate today, it's been a little dry, so I figured I'd give a real-life example, which some of you may know. But the judge of the Quebec Superior Court, Michel Jeriot, who was found to have just, I think it was 13 days before he was elevated to being a judge, he had actually been caught on video buying cocaine. It's sort of a true crime story out of the pages out of the Netflix evenings that we may spend. But Judge Giroux was challenged in 2010 there was a complaint to the Canadian Judicial Council, and it was pretty clear that when you have a judge on video buying cocaine from one of his clients who was then before the courts, that you really don't want that particular gentleman on the court. If you want to talk about something that brings the system of justice into disrepute, that'd be it. Well, the case started in 2012. It didn't end until 2021, when the Supreme Court of Canada refused to hear Judge Jeriot's appeal. At that point, imagine this, he'd managed to use every possible legal avenue to fight the finding that he was not qualified to be a member of the judiciary. He fought it, well, as you can imagine, those of us who are trained in law recognize that there are many ways to be creative and be litigious. And this gentleman was very litigious. Not only that, under the previous law that we had, the people of the province, the taxpayers, had to pay all his legal fees because he was a judge and it was under the judicial complaints process. So let me point out one thing this bill does, Bill C-9, obviously learned a lot from that experience. You don't want to have someone who's challenged dead to rights. They shouldn't be there as a member of the bench, able to keep exploiting every possible appeal and charge the taxpayer for his legal fees. And also, there should be a way of limiting how many accesses to judicial review through the federal courts someone in this situation should have. So Bill C-9 does something quite straightforward, which I haven't heard mentioned yet today, which is it says that if a judge going through this process wants to find ways to appeal, they're all in C-9. The only court that a judge who is being challenged in this way can get to is the Supreme Court of Canada at the very end of the process. Can't keep finding a judge somewhere to hear some aspect of a complaint the judge is fighting. So just to make it clear, you go through under this, you have complaints, you have a screening officer, you have a reviewing member, they can put certain kinds of review panels and then hearing panels together, but they're not clogging up the regular court system. And the judge is precluded, the judge that is the subject of the complaint, is precluded from going to any other court, but at the very end, having the right to an appeal to the Supreme Court of Canada. So I think that, and of course, the law also gets rid of the idea that the people have to pay for the legal costs of a judge. So the only opportunity to appeal to the courts under the new process, under Section 158 of Bill C-9, specifically bars any legal challenges or other forms of judicial review. This is a very helpful change. Everything about the way the bill has been constructed has been the subject of a great deal of consultation due to cases, and there haven't been a lot of cases, let's face it, in the 40 years since the Canadian Judicial Council was created, as far as I could find, and it was the same figure that the Honourable Member for Esquimalt Saanich used, so I think it's probably right, was that there were only 14 reviews in the last 40 years, which speaks to a very high level of ethics, a very high level of integrity within our judiciary. But if you do have a problem, you have very large stakes in getting this right. You don't want frivolous complaints from, for instance, people who have lost cases in front of a judge, having that disaffected previous litigant having the right to make a judge's life hell, to pursue them in ways that subject them in social media or wherever to unfair charges. The judge, subject to a complaint, clearly has rights and has to be treated fairly. That side of getting the balance right is well reflected in Bill C-9. The other aspect is you don't want public confidence in our justice system to be shaken by having someone serving as a judge who clearly does not meet the standards of ethical conduct, the ways in which it's expressed in this new bill. The ones that used to be there are infirmity and misconduct and failure of due execution. But this is new but relatively traditional. The judge is in a position that a reasonable, fair-minded, and informed observer would consider to be incompatible with the due execution of judicial office. In the time remaining, Mr. Speaker, I just want to mention for all of us here to think about the benefits of this new approach. And the previous, well, the system we're currently under, really was a binary choice. The judge is off the bench or the judge is on the bench. This new system says, well, maybe the judge needs some training. Maybe the judge needs some counseling. Maybe the judge needs a warning. So there's a different approach here that, again, lets something short of the kind of misconduct that says the judge must leave the bench altogether, that allows for help. I mean, one can imagine these are stressful positions, and mental health issues affect everyone in every profession. So there could be conduct that's questionable, but on the other hand, overall a good judge. C-9 allows that judge in that circumstance to be treated fairly, but it also protects the public and the taxpayer from a judge who will do absolutely anything to stay on the bench, even if they've been caught, as in the case I cited, on video buying cocaine. So with that, Mr. Speaker, I know I haven't used all my time, but I hope we can expedite the passage of this bill. It has been around even longer than some members have mentioned because it was S5 in the last Parliament in the Senate, died during the election on the order paper. So I think I now have used all my time, Mr. Speaker. Thank you so much to all my colleagues, and let's get this bill passed.
Questions and comments? Questions et commentaires. The Honourable Member for Nanaimo, Ladysmith.
Oh, thank you, Mr. Speaker. I'm not used to being able to go first. Thank you. And thank you to the member from, of course, from Saanich Gulf Islands. I agree with so much that was said in the intervention today, and again reinforcing the many reasons why we need to be moving forward with these changes around the Judges Act and getting this to committee and moving forward on what we're all agreeing on today. I may be new in this role as a member of Parliament, but I sure do cherish every moment to stand up and speak in this chamber, and I hope that never changes. And I reflect on the fact that our time may not be being used in the most efficient way right now. We have so much that's happening. I'm hearing from constituents who are worried about the climate crisis that we're in, who are struggling to make ends meet. And I'm wondering if the member can share a little bit about how she feels about us using our time in the best way possible to speak to the concerns that we're hearing from constituents day in and day out.
The Honourable Member for Saanich Gulf Islands.
And thanks, my honourable colleague from Nanaimo, Ladysmith. Well, I mean, we do have a responsibility to look at every piece of legislation, but when you spend an entire day on a piece of legislation and nobody can oppose it or suggest we really need to get it to committee for amendments, this is a bill that was essentially drafted by the Canadian Bar Association and numerous studies looking at the Canadian Judicial Council and with full engagement of the existing Canadian Judicial Council. So it's an excellent piece of legislation, well drafted, and I agree with the Honourable Member for Nanaimo Ladysmith. It's almost a year to the day, 3 years to the day that this Parliament passed on June 18th, 2019, the motion that we are in a climate emergency. We've yet to act as though we understand that we are in an emergency. And I think the more that we talk about anything else, the closer we go to a place that's a point of no return for our own children.
Questions et commentaires. Questions and comments. L'honneur of the Deputy.
The Honourable Member for Abitibi, Bay James, Nunavik, EU. Thank you, Mr. Speaker. I thank my colleague for her speech. I feel that this bill is very positive. It will also make it possible to decrease the length of processes. There will also be a mechanism to deal with less serious complaints. There will also be consequences for the behavior in question in the complaint. So does my colleague agree that we should move quickly with this bill? The Honourable Member for Saanich Gulf Islands.
Merci, Monsieur le
Thank you, Mr. Speaker. I thank the member for Abitibi, Bay James, Nunavik, EU. I agree. I fully agree. This is a good bill. It is well thought out. It is the result of a lot of study and reflection. I think that it is incumbent upon us to do everything that we can. To adopt this bill as soon as possible. Questions and comments?
The Honourable Member for Hull-Aylmer.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Speaker. I thank the member for Saanich Gulf Islands for her speech today. I agree with her that the fight against climate change is important. It is an existential challenge for our generation. I hope the member agrees with me on something. I'd like to hear her thoughts on it. The importance that everyone work together to fight climate change, and in order to do so, we need social cohesion. And it's very important for those who are racialized or in minority groups that we pass such a bill. Why? Because that will give Canadians trust. Canadians from all walks of life, the confidence and reassurance that when they appear before a judge, before a court, that they will be respected, that they will be treated with respect in their hearing. The Honourable Member for Saanich Gulf Islands, 20 seconds or less. Thank you, Mr. Speaker. I thank the member for Hull-Aylmer. It is clear that we need a system that gives each and every Canadian the confidence that the system will treat them fairly, that there won't be any racism in the system. But it's clear that right now there is institutional racism in every institution, in every province. Our system is racist at the core, and that's why we need to do